The judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the state of New York, may now draw near, give their attendance, and they will be heard.
People versus Perry Ford.
Ready.
May it please the
Weinstein.
court, I'd like to start out with the two related issues, the use of defendant's silence when he was given his Miranda warnings, and his later request for an attorney when he was again given them, both used to rebut his insanity defense. A couple of threshold issues stressed by the people, preservation, and with respect to the silence issue, the retroactivity of Wainwright against Greenfield.
Mr. Weinstein,
Yes,
you concede that it would be all right for rebuttal, to bring it out on rebuttal during the course of the objection which was first made. Was the argument that you're now making preserved for our review? And if so, where?
Let me start out that this is an issue which need not be preserved.
So then you're not claiming that it is preserved?
Oh, I am too, yes. But I think we don't even have to reach that in view of the fact that comment on silence of a defendant is so fundamental it need not be preserved. That was the holding of the leading case on fundamental error, McLucas, where there was a comment by the court on...
Do you know how narrow McLucas has been made since McLucas was first decided? Almost a sliver. The only thing that survives is the words fundamental error, which has been interpreted so many different ways as to render McLucas itself almost meaningless.
Well, I trust that the sliver is big enough for this case to slip through.
But assuming it isn't,
All right.
where is it preserved?
Very well. With respect to silence, the issue came up when the prosecutor asked for an in limine ruling that he could present the evidence of the detective about silence on rebuttal. He acknowledged that it couldn't be used on his direct case. And his language, it wasn't elegant, but I think it's enough to raise the issue.
He says, I would feel that would be more appropriate on rebuttal in light of Your Honor's decision.
That's right, and the court ultimately agreed with him, and there was in the colloquy discussion of the defendant's exercise of his constitutional rights, and
This was all in the context of the matter being prejudicial or inflammatory, and particularly the objection really rested on the inflammatory nature of the evidence, didn't it? The immediately
no.
preceding page.
Right, yes and no, if I can explain what I mean by that. The people make a big issue of that. The issue was raised by the, let us assume the defense counsel said nothing. The prosecutor says, in effect, there's a big constitutional question here. I know I can't use it on direct. I intend to use it on rebuttal. And the court says, fine, go ahead. All right, the issue was presented to the judge ruled on it, and even in the absence of express complaint by the defense, I would think that's enough. After all, particularly under the new amendment to 470.05 that refers to a protest, and I think where the prosecutor raises an issue, it's as much a protest as if the defense raises it.
We're talking about due process now, though, Mr. Weinstein. Where is the due process argument you're now making raised in the record?
Nobody used the magic words due process, conceded.
How about sounds like due process?
I think this has the feel of due process running all the way through it. I don't think anybody could say, oh no, we meant such and such. Now, it's true, the defense raised other aspects of it. He was trying to bolstering the argument that it was inadmissible by saying it's inflammatory, that it was some kind of a lay witness giving expert testimony. I'm not relying on those, but he was certainly objecting to its use. And my thesis is that the prosecutor's raising it as an issue is equivalent in this situation, when he asked for an in limine ruling, to the defense raising it.
Whether the prosecutor raises the issue or the defense raises the issue, isn't the key, the significant inquiry, whether the issue is actually before the court? And is the issue, the due process issue, in any way before the court?
Well, as I say, they didn't use the magic words, but first there was the initial application by the prosecutor referring to the defendant's exercise of constitutional rights. Later, in a related argument, a couple of pages later, at page 29 of the appendix, the prosecutor compared this testimony to the previous testimony of the detective who had testified about a statement the defendant had made, and the prosecutor referred to depriving defendant of his constitutional right to remain silent.
Mr. Weinstein?
Yes, sir.
You indicate that the magic words weren't used, but is it not so that in the Miranda-type asserted error, that specificity is required with respect to preservation? And isn't that what we're dealing with here?
Well, except if you're referring, as I believe, to people against Tutt,
See?
there was a little vague. A different aspect of the issue was raised at trial to the one that was ultimately raised on appeal, because there was room for both. Here, there isn't any room for both. There could only be one conceivable issue, the use of the defendant's silence as evidence against him. And I think that's enough. If we go to the, a very similar thing came up in the Second Circuit on exhaustion in People Against Day, where nobody at trial, referring to, I believe it was intrusion, prejudicial intrusion by a trial judge, nobody said due process, but the court ultimately ruled this was obvious they were talking about due process, and therefore we will consider it to have been raised. I think that's the proper approach to take. Now, Greenfield, of course, was decided after this case had been affirmed in the appellate division, and the people raised a very strong retroactivity argument.
Was it after leave to appeal
That's
had
true.
been denied?
Yes, yes, Your Honor.
So that really poses the problem, doesn't it?
It poses a problem, certainly. We go back to the leading cases on reapplication or reconsideration of leave after the initial denial, and we have Torres, which was 2.5 years after the initial denial, and we go back to the earlier case of Muller, which was 6.5 years, and those cases said no, that's no longer on direct appeal. The question is whether that is a bright line cutoff. Once the application is denied, you are no longer on appeal. I think where you have only a couple of months, less than 3 months in this case, it still should be considered on direct appeal. There's no need for a bright line cutoff. I'd like to pose a question that what didn't occur in this case, but if the initial application had been made and the judge considering it had been advised, we are waiting for an opinion from the Supreme Court, please hold this, I think any of the judges on this court would have done so. In which case, if the Supreme Court had then ruled in the defendant's favor, I don't think anybody would have said it's no longer on direct appeal. Perhaps that's what I should have done. Unquestionably, I should have done that, and I didn't, and I'm embarrassed that I didn't. But I think we're faced with the same conceptual situation. Promptly after the denial of leave, a controlling case comes down. I think there's a world of difference between that and waiting a couple of years or 6 years. If I'm wrong, I'm wrong. But I think, again, I go back to the fact this is such a fundamental error. The use of silence has been condemned so often in this court and the federal courts that there really is no retroactivity problem at all. There's no break in controlling law. It's not like the question we face on the Batson issue here, where there is a substantial break.
So you would argue if the issue is preserved that we could reach it under state law, state constitutional law?
Both state and I think under federal, because even under the federal law, except for 2 out of 12 circuits, there was no contrary ruling. It was a new issue, It was not one that had ever been relied on in the state courts here. There's no prior case saying that this was permissible. No prosecutor ever relied on any authority of this court or any statute saying this was proper. Moreover, the other retroactivity consideration is the effect on the administration of justice. We're not opening the prison doors here. I doubt if there's another case another defendant in prison who could possibly raise this issue. It's a new matter. It's not going to have any effect. And therefore, I think as far as retroactivity goes, something that need not be considered. Particularly since, picking up what Judge Hancock said, the New York rule on prohibition of use of silence goes back decades. I think it was at least back to 1902. This is no new law at all. The question of the request for an attorney raises very similar issues. The preservation is much more explicit. It was raised in a request by defense counsel for an in limine ruling, and he used much more express language. He referred to a request for a lawyer as a constitutional guarantee from which inferences should not be drawn. And later, after the court ruled, he again moved to limit the prosecutor from eliciting conversations about, quote, various rights, the right to counsel. Now, I think he didn't say due process, but I think that's certainly so close that there was absolutely no mistaking what he was referring to. It's ironic that although the request for counsel was raised in the Supreme Court in the Greenfield case, it wasn't ruled on. So here we have no retroactivity problem. It's not much we can do with that, but I think it's very interesting. Going to the merits, there is, I submit, no difference between a request for an attorney and the assertion of the right to silence. When a person being questioned asks for an attorney, it's certainly implied that he is asserting his right to silence until he has an attorney. Justice Rehnquist in Greenfield took a completely different view, with Justice Berger concurring, but the views of two justices don't make a rule of law, particularly where the right to counsel in New York, and I think to a large degree in the federal system, is given greater protection than the assertion of the right to silence. A defendant can, after asserting his right to silence under appropriate conditions, can go ahead and make a statement. Where there's a request for an attorney, that's binding until an attorney appears and is present when the rights are waived. There's a further question on the merits of whether it has any probative value. Again, Justice Rehnquist thought that a request for an attorney has more probative value than silence, but the cases that the courts that have considered the issue have pretty uniformly held that there is no probative value whatsoever. And I believe that's the position that this court should take. There are two other issues in the case: the unconstitutionality of the attempted murder conviction.
Your time has expired, Mr.
Very well.
Watson. Thank you very much. Noddington?
May it please the court. Good afternoon, Your Honors. I think I'd like to begin at the other end of the case, if I may, and that's with the Batson claim. Not because I think that it has any merit at all, but that's the kind of allegation that requires a response. I would concede preservation, but clearly this is a non-issue. No assistant district attorney in Bronx County practiced racism in jury selection. There were 2 blacks in this jury. This is just not an issue that happened at all. If you look at my brief, there are a number of excellent case-related reasons for why black jurors were excluded. They'd had brothers in prison. One was arrested. Some worked in hospitals. One juror had seen a psychiatrist. There are hundreds and hundreds of case-related reasons here having nothing whatsoever to do with the color of the jurors' skins. That is just not an issue in the case.
Is that something that we can pass on at this level, however, or is that something under Batson that in any event, if it rose to a certain level of prima facie validity, would have to go back for a fact-finding court, in quotes, to
Well,
resolve?
the rationale of the Batson decision is that reasons should be given at the time. Admittedly, specific reasons were not given here. But the prosecutor did state that he was exercising his challenges based on experience, hunch, whim. Justice McNabb said that he could see a number of reasons there. And I think at the appellate division and before this court, the record demonstrates enough reasons that I think this court, with its review powers, there's enough remaining in this record for this court to find that these were case-related reasons and that remand for a new hearing in this case really would not be necessary. I think there's enough in this record for this court to find that these challenges were exercised properly.
Are you conceding that the Batson issue is before us?
No, I'm not, Your Honor. I think that it is non-retroactive. I think in People v. Torres,
It's been so held to be non-retroactive.
that's right, Allen v. Hardy on collateral attack, and under the rule of People v. Torres and People v. Mueller, I think that this is a collateral attack, so to speak. So I am not conceding retroactivity at all. I raise it only because of the nature of the allegation. It requires a response, and I'm making one. With respect to the Greenfield issues, I agree with Your Honors that I don't think this was properly preserved for the court's review.
We didn't hold that.
Well, Your Honors have
You
intimated,
agree with the questions.
I agree with the
It's
questions.
the answers that count.
That's right, but I think they're excellent questions, Your Honor. And if I were answering your questions, I would disagree with Mr. Weinstein. I think they have been unpreserved. The rationale of Greenfield is that it's unfair to use the promise of the Miranda warnings against the defendant to prove guilt, consciousness of guilt and insanity. Here, that was never done. That type of objection was never made below. The new 470.05 doesn't apply at all. Had the prosecutor or had defense counsel said that this violates due process, this violates the promise of the Miranda rights, and had the court passed on that, perhaps there would be a question of law. But I submit to Your Honors that that didn't happen, and as a result, that it has been unpreserved, and in any event, under People v. Torres, non-retroactive.
What was the invocation of the right to remain silent? What about the invocation of the right to counsel?
That's a little different, Your Honor. Under Carmine A, I submit that perhaps preservation with respect to the exercise of the right to counsel requires somewhat less preservation than the right to silence. However, one, the defendant, at least with respect to the lineup, did not have a right to counsel, so he was invoking a right that didn't exist. Hawkins makes that clear. On the merits, the invocation of the right to counsel shows the operation of a mind in the way that silence does not. Silence is insolubly ambiguous. However, with respect to sanity, a man who understands that he needs an attorney has a mind whose mind is functioning in the sense that he knows what's going on. This, I submit, is probative, and it was introduced purely with limiting instructions. This didn't go to guilt at all. This is purely to show that his mind was acting rationally, and I submit that's proper. And in view of this case, where the invocation of the right to counsel played such a very, very small role at trial, I mean, the proof here, Your Honor, is absolutely, utterly overwhelming. There are 4 eyewitnesses to this case. Perry Ford wrote a letter. The accomplice testified. We detailed the way his mind worked from the start all the way through the crime to the end. As a matter of fact, the psychiatric testimony was remarkably weak. Dr. Stone could offer no opinion as to the way this mind was the man's mind was working at the time of the crime. Dr. Cornet, his own expert, said that this man, well, under his diagnosis, would have to have been sane at the time he committed the robbery, insane at the time he shot police officer Argiano, and then sane later on. Excuse me, Your Honor.
Are you telling us that if it had been preserved,
And if it were retroactive,
and if Wainwright did apply, and you argue that neither of those conditions prevail, that this would be okay anyway?
clearly harmless error. Yeah, clearly harmless error, if error at all. And that was the...
Would there be a violation of the Wainwright rule?
There would not, Your Honor. As a matter of
Why
fact...
not?
Wainwright is a silence case. It is not a counsel case. And that counsel point was not briefed before the United States Supreme Court, and Justice Rehnquist and Justice Berger distinguished that case.
Isn't in this state, wouldn't that be a fortiori?
I don't know, Your Honor. So far as I know, the only case in which this court has even touched on the issue is RICO. And that was a case where they absolutely took a statement in violation of the right to counsel, and they used the content of the statement against the defendant to prove guilt. That I don't think is this case here at all. Here we merely use the invocation of the right not to prove a consciousness of guilt, the same way it was used in Al-Kanani. Here it was merely introduced with limiting instructions purely to show the fact that this man's mind was rational. That, I submit, is permissible under the law of the state, even though it involves the right to counsel. I understand how much this state values the right to counsel, but, you know, it is not all there is. I mean, you know, there is a societal interest here, and I submit that certainly in the limited context and the way it was used in this case, that
You agree with the math student who said not every matrix has universality?
You have it. That's right, Your Honor. No, Your Honor, in sum, I think, with the exception of the Batson claim, nothing has been preserved. None of these claims, I submit, should be applied retroactively, and should this court find any error at all, the proof here is overwhelming, and any error is harmless. If there are no further questions, I thank the court, and I rest on my brief.
Thank you very much, Mr. Kennedy. People versus Vernon Edwards. Mr. Brenner, what was the order that occasioned the retrial here?
The order that occasioned the retrial was the dismissal of the lower court, by the lower court, of the count, not the dismissal, the declaration of a mistrial that occurred upon the failure of the jury to return a verdict on that particular count. There was no formal order entered. As I had indicated, I perused the record. There was no written order entered. It's clear, however, that at that point, the district attorney had one choice. He could present the case to a grand jury. His delay in doing that, we contend, is a violation of the statute.
Why wasn't the filing of the indictment the thing that started the second action?
Well, in Osgood, this court said that when you have an accusatory instrument that's dismissed, you can't just assume that everything that precedes the filing of a second accusatory instrument doesn't count for purposes of speedy trial. Now, I recognize this case is different because you didn't actually have an accusatory instrument. You had a lesser included count. But it's functionally the equivalent of the dismissal of a prior accusatory instrument. When the jury comes in and says, we can't render a verdict on a lesser included count, that's the equivalent of the dismissal of the prior accusatory instrument. And it's at that point that the 90 days begins to run. And the district attorney, we submit, is not in a position to just sit back, try to take the case to trial again, be rebuked, as it were, by the trial judge and told that under People versus Mayo, which is a clear decision, you can't do that. You've got to either, proceed by an information or resubmit it to a grand jury. There was simply no excuse for the failure of the district attorney to do anything once the prior jury hung. If he wanted to retry the case, he had to do something within 90 days. He failed to do that. Your Honors, I'd like to discuss the Batson issue because I have it in this particular case, too.
Should we wait till Griffin versus Kentucky comes down?
I would have no problem with that, Your Honor. I believe that if the Supreme Court holds that it's retroactive, that will be binding on this court. If it holds that it's not retroactive, this court under the state constitution can go to the contrary. I'd only like to point out that in terms of retroactivity or non-retroactivity, the basic considerations, new law, reliance, integrity of the fact-finding function, really weigh against the position that the district attorney is taking of non-retroactivity. There's a vast difference, we submit, between non-retroactivity on collateral cases where you can have situations years after the fact and non-retroactivity on direct appeal. Mr. Kenneth Jolson, the trial lawyer in this case, was aware of Judge Nickerson's decision in the McCrae case in the Eastern District. He cited it repeatedly below. In addition, the district attorney should have been aware of the decision of the Second Department in People versus Thompson, which was a case that was more or less on all fours with McCrae, but never came up to this court. The appeal was withdrawn for reasons that don't appear in the record. There really is no basis for a district attorney at the time of this trial to claim reliance on either McCrae or on Swain. In terms of whether or not the district attorney should have been aware that this was a live issue, an issue in controversy, there can be no question but that it was. I mean, Batson-type cases were filtering up through the courts all over the United States. In New York, we had McRae out of the Eastern District and the Second Circuit. So in terms of an argument by the district attorney, well, we relied on Swain. I mean, we didn't think we had to do anything different. There's really no basis for
And
that.
when the court said that a prima facie case was not made out, what exactly did it mean?
I think what the court was saying was that under McRae, under this court's decision in McRae, there was no showing of systematic, that is, over a period of cases. There was no showing of that kind of discrimination. In the very same paragraph where the judge said that there was no prima facie showing, he also said, I think his words can be interpreted to say, I think that what happened in this case is that the prosecutrix did strike these people because they were black. The judge said, this kind of thing happens all the time. For years, defense lawyers and prosecutors have felt that certain segments of the population did not correspond with the kind of people they wanted on the jury. And immediately after that, the judge said, but I think that the Court of Appeals has said that that's all right. That's the McRae decision, which relies on that portion of Swain, which talks about multiple cases. So I think that that's what the judge meant. I do not believe that there is any basis for reading in the record of finding, no, I don't think the district attorney was striking these people because they're black. In fact, the prosecutrix intimated, or at least gave up a little bit. She said, my sole reason for striking these people was not their race. And then she went off to talk about tone of voice and demeanor and things like that. But I don't think there's any basis for reading in the record of finding a fact that the prosecutrix did not, at least in part, strike the blacks precisely because they were black. I'd also like to point out to this court a fact of which this court is probably aware, and that the lower courts in this state, the appellate divisions, first and second and third department, have been uniformly applying Batson across the board without any discussion. I don't know whether or not, I know in this case, no, I'm sorry, Batson was not decided in this case within the appellate division, so there was no retroactivity issue. I don't know if the district attorneys in other counties are arguing against retroactivity on direct appeal, but if they are, the appellate divisions are giving the back of the hand to that argument, because all of the cases that we cited in our reply brief indicate that Batson is going to be applied on direct appeal, which is part of the general rule. Absent some real change in the law, you apply the laws that exist at the time of appeal. And this is not a change in the law. The difference between Batson and Swain is that Batson adopted a new procedure for vindicating a constitutional right that had been acknowledged by Swain and prior cases to have existed for over 100 years. Batson is not new law in any substantive way. It's only new law in terms of the procedure that is used to vindicate a previously noticed and announced constitutional right. So I think for all of those reasons, in addition, of course, I think to the obvious public policy argument, that for this court to say, for technical reasons, if I may put it that way, that it's no longer all right to exclude blacks because they're black, but it was okay prior to the time that Batson was announced, I think is just not sustainable on public policy grounds.
It wouldn't be the court saying that it was okay in any moral or ethical sense.
I understand that,
But
Judge.
it is, quite frankly, a very different burden for a district attorney, is it not?
Well, I understand. It is a different burden. Our point is that that is a procedural matter. And I didn't want to be overly technical. My point simply is that in terms of the perception of the public, and I think that's one of the attributes of public policy, in terms of the perception of the public with regard to a decision by this court that Batson was not to be applied to cases on direct appeal, I don't think you can make a real principled distinction, or a properly principled distinction, if you will, between applying it to cases which arose after the date that Batson was decided.
You're
and
not
to
saying we
cases
couldn't
on
make
appeal.
the principal distinction, you're saying it wouldn't be understood or perceived.
It would not
because
be
you're making
perceived
an
as a
argument to
principal
public
distinction.
perception.
Precisely, Judge. That's
But
exactly what I'm
analytically,
saying.
it could be made.
Analytically, it could be made. That's why, that was my choice of the word technical. Analytically, it could be made. I think that the public's perception would be that they really wouldn't understand that. And I think that the factors that go into a determination of whether or not a, quote, new law should be applied on direct appeal all bear in terms of retroactivity. I don't even think this is an issue of retroactivity, to be perfectly frank. I think all the factors that were involved in determinations of retroactivity, none of those are really present
Thank you very
in
much.
this particular case. Thank you, Judge.
Selker? You concede, do you not, that the literal reading of the statute supports Mr. Brenner's position with regard to the running of time?
I don't think it's precisely covered by the statute, but I think Mr. Brenner will be surprised to find that, in fact, I do think that's the better reading, that November 10th is an appropriate time to envision the commencement of that action. However, I don't think it can be viewed as separate from the felony action under which it was prosecuted, and that it would be ludicrous to say that the district attorney could try that felony case, then go and obtain a separate indictment for the misdemeanor cases and try the defendant on that. The legislature did not appear to envision this situation. However, this court, in its interpretation of legislative intent in the Osgood case, has viewed charges that go together as though they were one charge. That is really the...
Is it significant here that consolidation took place only after the defendant had a right to dismissal?
I don't think it's significant, Your Honor. These charges arose under the original felony indictment, which obviously was intended to be tried together. All the charges were going to be tried together. I think the other possible view, and I do believe it's a viable view, that the action commenced when the second indictment was filed. The reason I don't believe that's the preferable view is that that would, in fact, permit a district attorney to go ahead, try the felony case, and wait more than the 6 months. If the action is seen to have commenced at the time of the mistrial, the very most that will be obtained for the district attorney in terms of time will be the 6 months. And I think that's a better view. Although, as I say, I don't think either is precluded the way the statute is now written or under the cases that have now been decided. With respect to the Batson issue, initially I would like to clear up what I consider to be a very serious misstatement in the defendant's reply brief, in which I believe was promulgated in his argument today. And that is his view that the prosecution has conceded that the district attorney was motivated by racial bias. There was no change in the law in that respect. That was unconstitutional prior to Batson. As counsel did point out, Batson changed the district attorney's burden, as Judge Kaye also pointed out. But it was unconstitutional prior to that time to use racial motivation to exclude jurors. It's also against the ethical view of the Westchester County District Attorney's Office. The prosecutor in this case, when asked or when challenged by the defense counsel at trial, stated that she did not use that as a reason for her challenge. However, she was aware, as the court was at that time, that she did not need to state her reasons unless a systematic pattern of discrimination had been shown, which it had not been in that case. I think it's important to correct that misstatement because although the arguments that I would like to make are procedural, I don't want this implication to confound the real issues of this case. I also don't think that the real issue in this case is retroactivity. Either the Supreme Court's going to find Batson retroactive to cases on direct appeal or it is not. And once that decision is made, this court will undoubtedly make a decision in accordance with that.
Unless we made it in the first instance under the state constitution.
Absolutely. But that will only affect a handful of cases. If you find that it is retroactive, it will affect this case. But there is an issue in this case that will affect all future Batson cases. And I think that's the one that should be focused on and one that should be determined by this court with this opportunity to do so. That is whether a defendant waives his right to review of that issue when he fails to provide a record upon which review can be meaningfully determined. And as opposed to the case that was argued just prior to this one, this defense counsel did not request that the voir dire be transcribed. Now, in his reply brief, appellant's counsel has given several reasons why it wasn't necessary to record the jury voir dire. Initially, he said that defense counsel at the trial level didn't anticipate that the issue was going to be determined in that fashion and did not realize that a record would be mandatory. That's patently silly. From the very beginning of the jury voir dire, it was obvious that defense counsel was planning on making this claim and was going to attempt to show that racial motivation was behind the challenges. Another
You say
argument.
it's the burden of defense counsel, even if you should apply Batson?
Always.
to-
It's always the burden of the litigant making the claim to provide the record for the determination of that claim.
Even though under Batson, the burden of proof is the other way.
It's the defense counsel's burden to make a prima facie showing. The prima facie showing is not merely made by excluding all blacks from the jury, as the Supreme Court made clear in Batson, because it sent the case back. In Batson, that is what occurred. That was not sufficient. It sent it back for a hearing for determination of whether or not that plus other circumstances of the case would show. And as Mr. Coddington pointed out in the argument before mine, there were instances in the jury voir dire where this court could make a determination, and that's exactly what cannot be done here. And that leads to appellant's counsel's next argument in that point, which was that the legal arguments alone were sufficient, that defense counsel made his case by his legal arguments. Well, what he said was, I believe the prosecutor is, loosely translated, I believe the prosecutor is using her challenges in a racially improper manner, in an improper manner. I don't see any other reason for their exclusion. Well, that's precisely why the record is needed. That's precisely why a transcription of the jury voir dire is necessary.
What authority do you offer for the proposition that in a case like this, where defense counsel claims to have made a prima facie showing under Batson, that then it should be up to the defense counsel to see that a record is made?
Defense counsel is raising the claim. Defense counsel, my understanding is that defense counsel has the burden of providing a record where this court, where a review court can review the record. Merely making a prima facie, he not only did not provide the record, but he did not provide an opportunity for the next step, which would be the district attorney to rebut that prima facie case.
Nor did the district attorney provide that opportunity.
That's correct. But however, at that time, I believe it was proper for the district attorney to rely on the law that was in effect at that time, which was that she really didn't have to do that.
Yes, but this is a Batson claim that's being asserted.
Oh, right, and that really...
So under that rule, it would be the other way.
Well, it was up to defense counsel to provide the record at that time. Really, whether or not a record can now be created is, I think, a question of whether or not there's some kind of reconstruction hearing that could be held. And I wanted to cover that point in a minute, but I don't think it's really the same issue, because I think the defense counsel, any litigant, he knew he was going to make this claim. It was up to him. The trial judge gave him several opportunities. Make whatever record you wish. Please make whatever record you wish. He did not make the only good record that could be made, and that was the question and answer of the jurors.
Ms. Selka, before your time expires, I'd like to ask you one question back on the 3030 issue. You conceded that you're asking the court to give a rather generous interpretation of the statute, if I may phrase it that way. Is that too much to ask in light of the fact that the timing mechanisms are totally within the control of the prosecutor, and they may be trying to take undue advantage down the road precedentially, not the prosecutor in the personal persona?
That's why I think that that's a better view, to go back to the time of the mistrial order, because it would not permit the prosecutor to take advantage longer than the 6 months that the felony indictment, which was still pending, would already give them. In other words, they would have the 6 months that they had for the other charges, and it would not permit them to later bring another indictment on that case. Could I just have give one moment to reconstruction?
Your time really is up, Ms. Selka. Isn't it in your brief, covered adequately enough in your brief?
I don't know.
Well, you should have thought of it then, when you had all the time in the world.
That's right, I did. Thank you, Your Honor.
Thank you.
Your Honor, may I just have 30 seconds? Just to cite the court to a simple a page in my appendix concerning whether the district attorney conceded.
What page?
Page A201.
Thank you very much.
Dealing with the reason for the exercise of the peremptory challenges.
Thank you.
Thank you.
Tantleff versus Truscelli.
Ready at the door, please.
Mr. Foreman, you contend that the $100,000 should be opened as an option price until such time as the property is actually sold by deed?
That's correct, Your Honor.
That's the way you read this contract?
Yes, I do, Your
And
Honor.
if someone would read it as Judge Gibbons read it below, that would be the end of this very narrow sui generis case,
No,
which
we're
came
not-
to us before the enactment of Chapter 300.
I don't think that would be the end of it at all, Your Honor, because I do think there's another important issue. However, I do think that the language is clear. The first refusal option specifically speaks of the receipt of an offer from a third party. Had the parties wanted to, they could have used that same language with respect to the fixed price purchase option, but they did not. What they did write is that upon the sale of the property, the fixed price purchase option would terminate. And there was never a sale involved here. All that was done was that a notice was given by T11 Partnership that an offer was in existence from a third-party purchaser to purchase the property at the purchase price of $300,000. That is not a sale of the premises.
Mr. Foreman, if you read that fixed price clause as you suggest, then the first refusal clause is rendered virtually meaningless.
No, I don't believe it does, Your Honor, because first of all, assume for one moment that the value of the property is less than $100,000, and it would have every meaning because it would necessarily mean that the purchaser, the third-party purchaser, would be offering something less. In addition, the cases have held, as stated in the Prescott case, that the meaning would then be given that it would be an acceleration of the right of the tenant to exercise his fixed price purchase option. That does not mean he would do so. He may not have a reason to purchase it at that time. We have a lease here with extensions that goes to the year 2006. In the event that the tenant does not exercise his right, then the landlord would have the opportunity to sell at a greater price. However, we have here a lease that was entered into on April 6, 1957. The plaintiffs here have fully complied with all the terms and conditions, including the payment of rent.
Does this make any sense, really, that this landlord now sits there and that no matter what the price offered, $10 million, the tenant can just sit there and say, sounds good to me, and then pick it up for $100,000? It doesn't seem to, you're
Well,
saying that he
I
just is a
think-
foolish landlord.
Well, Your Honor, that's the way it was negotiated in 1957. They knew in 1957 what the rent was going to be from 1957 through the year 2006. They also knew that the property had a possibility of increasing in value. The increase in value of the property should not cut off the right of the plaintiffs to purchase under the fixed price purchase option, and I believe that the Crowley case, Crowley versus Texaco, stated that very maxim, Your Honor. That is what they negotiated, that is what it says, and I believe that's what should be enforced by the court. And I mentioned before that there is another issue, and that other issue is the validity or effectiveness of the notice that was given. At all times involved here, at the time that the notice was given, the property was owned by the 11 individual defendants, other than Anthony Truscelli and Norman G. Heil. They were the owners of the property. The notice was given by T11 Partnership, and that notice was signed by Anthony Truscelli Jr. and Sadie M. Gregory on behalf of T11 Partnership, which was then described as a landlord. Well, it's unrefuted, Your Honor, that the property was at all times owned by the 11 individuals. It was never claimed that anyone other than those individuals, such as T11 Partnership, owned the property at any time. Nor is it alleged that T11 Partnership was the assignee of the lease. Not being either one of those things, they could not give the notice. They had no standing to give the notice. They were not the landlord and they were not the owner. All that's been claimed here is that a certificate of doing business as a partnership, was filed with the clerk of the county of Richmond. That could not transfer the title of the property, and that could not assign the lease. And it is submitted that the only ones who could have given that notice, such as to implement the provisions of the first refusal option, would be the 11 individual owners of the property. And it is not claimed that that notice was ever given by the individuals, only that it was done by T11 Partnership, which had no nexus at all with the property. That being so, the giving of the notice was invalid, void, and of no effect, and the exercise of the fixed price purchase option was therefore effective and valid. I believe that the interpretation of the word sold given by the appellate division really constitutes a rewriting of the lease by giving it an interpretation other than its clear and unambiguous meaning. We have a situation where when the notice was given by T11 Partnership, a contract of sale had already been entered into between T11 Partnership and this third-party purchaser. There has been no claim of any change of position, and in fact, the exercise of the fixed price purchase option was made at a time when the plaintiff still had a right to exercise under the first refusal option. They did not wait until afterwards, and they were still in a period of time when the landlord, or actually in this case T11 Partnership, could not have acted to commence the process of selling the property because the first refusal option had not been terminated because the time period in which for the plaintiffs to respond itself had not been terminated.
Would you agree that if the time within which the lessee could exercise his right of first refusal after receiving a notice from the landlord of the offer had expired, that then would cut off the fixed price option?
It may have, Your Honor. I think technically...
And that didn't happen here.
No, it did not happen
but
here.
Then you would have something that's not just an outstanding offer, but which can't really be a firm contract until the period is gone by, because whether the offerees accepted it contingent on non-exercise or whether he just holds off and doesn't accept, in either event, it can't be firm until the time within which the lessee can exercise has gone by.
That is absolutely correct.
That's the situation we have here. Now, if it's gone by, that could be something else again.
I believe that would be a different situation. Whether or not that would constitute a sale, I don't think it would, but we would have other equitable principles involved at that point because the situation would certainly be different. Presumably, the third-party purchaser would be under the belief that he was going to purchase the property. The landlord would be in a position of relying on the fact that the first refusal option had not been exercised, and I think equitable principles would come into effect. In fact, many of the cases cited in my brief hinge on the fact that there had been a sale of the property, which is a similar activity, which would have cut off, under equitable principles, the right of the tenant to purchase. But we don't have that here.
Mr. Foreman, this litigation has taken some 5.5 years to get to this point. I'm just curious, is that attributable to ordinary court delay, or is there some adversarial explanation why a litigation involving the alienation of property should take so long to work its way through?
Well, I can tell you that one of the reasons, Your Honor, is that the original attorney working on this appeal died suddenly. And there was a delay until other counsel was able to be retained, myself, and we were able to go forward with that at that time. And there was some delay at that point.
When was that?
That was in the beginning of, it was in March of this year. Prior to that, the decision of the appellate division was
It looked like, as I
1985.
viewed the record, it looked like 2 years at special term, 2 years in the appellate division, and a year and a half getting here. That seemed awfully long intervals. Obviously, it has nothing to do with the issues and the resolution of the case, but it struck me as something that I ought to inquire into if
I
there was
have-
a reasonable explanation for that.
I have no explanation for the delay prior to this appeal, Your Honor. I was not involved.
Thank you very much.
Thank you.
May it please the court, I'd just like to point out that there was an intervening fact which is in the record, and I'm sure the court knows it, that intervened between, and when we're discussing the question of whether a sale had taken place or could have taken place, and that intervening factor was a restraining order that was issued by the Supreme Court in Richmond County, and it was issued to the third-party purchaser and the landlord and/or the respondent in this matter today.
As a matter of curiosity, what is the status of the property right now?
The status is as it was when this litigation began, Your Honor. That is that there is a landlord and tenant relationship and it is ongoing. And there is a valid third-party offer to purchase the property. But I just would like to indicate that intervening factor, that is the restraining order of Judge Rubin, prevented the sale from taking place. I certainly think it makes good sense to just give the literal construction to the language of this particular case, as did the Second Department. What reason for putting in a right of first
Well,
refusal?
as soon as you ask the question what reason, then you're not really going into the literal language.
No, I'm not, Your Honor, but I suggest this to you, and this is my strongest point, and I think it's only logical. What reason for having a paragraph including a right of first refusal, if it was the intention of the parties that the fixed price option should live and override during the whole continuation of the lease and all renewals thereof? If that were their intention, there would be no reason to include the first refusal.
Not a bad argument.
And certainly, Judge, I think that's the reason that that first refusal was put in. Otherwise, it's superfluous language and it's meaningless.
If you read the words, not prior thereto been sold in accordance with the provisions contained in the first refusal option, that's the contingency in the fixed price option. Not prior thereto having been sold. If you read that phrase as meaning receipt of an offer, and say that receipt of the offer prior to the expiration of the first refusal time within which the tenant can accept has gone by, then really what would happen in the event that the sale didn't go through?
Well,
That it wasn't accepted. You'd still have a holding that that was a sale, and that could be a device to cut off the tenant's right to exercise the fixed price option.
under the circumstances that you've just described, it could be characterized properly as a device, but that's not what happened here, Judge.
Now, I understand. I'm just talking about the reading that you give it, which makes makes receipt of an offer sale.
Well, we had a receipt of an offer, we had an executed contract between the...
Contingent on non-exercise, I assume.
which was fully disclosed in that contract, that the prospective purchaser had in his contract. He had full knowledge that there was a right of first refusal. But I simply suggest that logic dictates that sale, the word sale, if you want to give strict literal interpretation to that word, we could not conduct the sale. We had to honor the terms of the lease by notifying the tenant of the offer. We had the intervening restraining notice from the court, so that the word sale, if you give it the strict literal interpretation, we could not have had a sale as it were. We did, and I think that what the landlord did logically went as far as he could go within the construction, within the language of the lease to effectuate a sale, was enjoined by the court from completing the sale, in fact, and the sale has never taken place, and indeed, as been described, the relationship between the parties is the same as when this litigation commenced. I would just like to counsel's point wherein he indicates that the T11 partnership was not a proper party to give the notice of the concerning dealing with the first refusal. The record is clear that when the appellant requested an extension of time within which to respond, which to respond to the notice of first refusal, that the appellant indeed went to this T11 partnership, asked for the extension of time within, and recognized, in fact, the T11 partnership, which the Second Department characterized as a partnership which was formed for tax purposes only, and that question was addressed by the Second Department. But the appellant did deal with the partnership, did ask for an extension of time, indeed, from that very partnership that now, in the brief and on appeal, the appellant sees fit to question the validity or the status of that partnership.
That does not create a question of fact as to whether the partnership was the owner?
Certainly not, Judge. The partnership is the owner, and the 11 individuals, in fact, are the owner, and the partnership acts under a power of attorney from the other 9. They're all related brothers and sisters, and all in the same family. And certainly, I don't think at this stage is the point to address or attack that question. And I think also, in my own opinion, it's not in my brief in this exact language, but certainly the appellant must be in some way stopped from now asserting or questioning the status of an entity which he has acknowledged as having that status when he asked, in fact, for an extension of time within which to respond from the entity he now questions its authority.
Thank you very much, Mr. Fitzpatrick.
Your Honor, may I have just a short reply? I did not use up all of my time, and I did want to reply to just a few of the statements.
A short reply if you think it's
Very short.
necessary.
The extension of time referred to included the words "without prejudice to the parties," and I do not believe that the execution of that document, which was intended to preserve the rights of the parties and maintain the status quo, should be interpreted against the plaintiffs herein. They were entitled to preserve their position, and that's what it was intended to do, and that's what it said. I also would like to point out that the reference to the power of attorney giving the signatories the right to act on behalf of all the other owners is dehors the record. It is not in the record. There is no power of attorney in the record. It was not referred to in any documents there, and it should be disregarded by the court. I would also like to point out that the contract of sale was entered into by T11 Partnership, and it is unrefuted in the record, and also in the briefs, that there was never a transfer of title to T11 Partnership or an assignment of the lease.
Thank you very much, Mr. Foreman. Cuffy versus the City of New York.
Ready, if the court please.
Stan, why wasn't there a special duty here when the city had been advised of the potential threat from these very people, to these very people, and relied on the existence of that protection to conduct their business as they did?
Judge, we don't believe that the city were advised of any threat by Mrs. Aikens. I'll start with that, although it certainly was not our main point. There is no evidence in this record of any act of prior violence by Mrs. Cuffy, not only toward any of the plaintiffs here, but toward anyone. Did I say Mrs. Cuffy? I'm sorry, sir. I meant to say Mrs. Aikens. So that the police were not advised of any threat by Mrs. Aikens whatsoever. Nor did the police owe a special duty to Ralston. I think it would be helpful, although I plan to start with a general issue, if I do start with the specific issues and then touch on my general issue at the end of my argument.
However you see fit.
There is no evidence in the record that Ralston Cuffy was aware of any statement made by the police. Ralston himself did not testify that he was aware of any statement made by the police. I should also add that he testified he was aware of no problem between his parents and the Aitkins. He testified that he had never spoken with Mr. or Mrs. Aitkins. He came to his parents' house purely by chance. I don't mention this in my brief, but the record shows that he stopped by at a friend's, and the friend had a gift for his mother, and he decided to go over to his parents' house.
But of course, if his parents weren't there, he wouldn't have gone.
There is no evidence that he would not have gone. That is the point I was trying to make. The point is that he went to his parents' house for an independent reason, which had nothing to do with his knowledge of their presence or not. There is no evidence that his parents spoke with him. Indeed, the only evidence presented on that issue suggests an inference that his parents didn't speak to him too often because he was not aware that the 3 relatives from England were even at the house.
Well, assuming the very best state of facts for the plaintiff, if he was aware that his parents were at the house and went to drop off the gifts, wouldn't a claim be stated?
Well, there's no evidence in the record that supports an inference that he was aware that his parents were at the house, Your Honor, because he specifically stated that when he went there, he would have liked to join them for dinner, but he wasn't dressed for dinner. In other words, he just didn't know what was going on. Now, if he were aware, I still do not believe, if he were aware that his parents were at the house, I still do not believe he states a claim because he was aware of no police assurance with respect to Mr. Aitkins. Mr. Cuffy had not reported any threat to Ralston in particular. Ralston was an adult. He lived in his own apartment. He was 26 years old. He had his own...
Need he be individually aware of the circumstances and need it be demonstrated that he personally relied upon the statements by the police?
Well, I believe that the precedents of this court show that every person who is to recover from a municipality based upon a breach of a special duty of police protection or other similar